There's nothing in the Constitution that gives the Supreme Court the right or the duty or the obligation to determine what is constitutional and what is not. Marbury versus Madison. It was a Supreme Court case where they granted themselves that authority. And for a couple hundred years, roughly, we have seen that deference given to the court. I think the court is the right place to make these types of constitutional judgments. But what happens if the court makes an unconstitutional judgment? What happens if the court itself violates the Constitution? Is there a remedy? So what happens if you have a rogue court, like, say, for example, in the Dred Scott case, that makes a decision that is clearly outside the bounds of what the Constitution contemplated? Is there a remedy? And so,
no constitutional mechanism to do that. There's nothing in place for that. Like, what do you do?
Well, I'll give you. Yeah, I mean, obviously, the way that was provided to change the Constitution was by constitutional amendment. And as you see, it's very hard to do because you have to have something passed with 2/3 of the House and Senate, and you have to get 3/4 of the states to ratify. So our founders clearly wanted it to be very hard to change the Constitution. That's why when you see the court change the Constitution in an unconstitutional fashion, in other words, create something that isn't in other words, amend the Constitution by creating something that's not there, they've short-circuited something that was supposed to be very hard to do, and there should be some remedy to say, no, you can't do that. Okay? And what is that? Well, what is that is the president or the Congress saying, you acted unconstitutionally, and we're not going to pay attention to that law. We're not going to pay attention to your ruling.